You're welcome to the Constitutional Talk, a video podcast by Lexamika. My name is Mahad Jisuze Mugaya. I'm your host, and this is our second edition of the Constitutional Talk. Today we have some very distinguished guests with us, and for what is going to be an interesting talk, and more so an educative one. But before I start, I want to send our shout-outs to the team behind the camera and the team at Lexamika and the team at Unipod. So the topic for tonight is we are taking a dive into the constitutionality of the proposed amendments by the NRM caucus that are soon going to be introduced into Parliament as they seek to amend the UPDF Act following the Kabaziguruka case as we all know it. Earlier on this year in around 31st January, as we all know it, the Supreme Court delivered a landmark decision, I think one of the best decisions in recent years, where it actually deemed trial of civilians in military courts unconstitutional. Now, it is important to understand that this happens in a context where there are many political cases, or legal political cases, as we may say, more so involving key opposition figures and figures in the legal fraternity, that is retired Colonel Dr. Kizabesije and Counsel Aaron Chiza, among others. Now, there's been a lot of contest there. There's been a lot of contest there about whether the military courts actually have the right to try the civilians. At this point, I'll introduce our panelists for tonight. Joining me on my right-hand side is Miss Atai Isabel Nicole. She's a law student at Makerere University. And Ms. Atai can tell us something about herself. Ms. Atai.
I'm happy to be here. My name is Atai Isabel Nicole, a fourth-year law student at Makerere University, and someone with keen interest in human rights and constitutionalism. I think all that I've really done is be a leader at my school.
All right. But you have a big interest in the Constitution.
Yes, I do.
Thank you. On my left is Miss Aloikin Praise. I think some of you might know her. Her face is more common. Opoloje is a law student at Makerere University in her final year, and also the winner of the Civil Liberties Human Rights Award for 2024. Miss Aloikin can tell us something about herself.
Hello, everyone. My name is Aloikin Praise Opoloje, as I've been introduced. I am an outreach merchant, very passionate about human rights, social justice, and protest movement. So I work in protest movement building. I'm currently working on a movement with a group of young people called We the People. And what we basically do is reach out to, young people in different areas, teaching them about their human rights, their civil rights, and their ability to use nonviolence resistance, especially protests, to agitate for change and hold leaders accountable. I'm glad to be here.
All right. Thank you very much. That's interesting. So as you see, our discussion tonight will be riding on the backs of the ideas of these people. So to take it off, to start, I'll start with Ms. Atai on my right. So Ms. Atai, as you're very well aware from the context that I gave, that we got a landmark decision last month but one, and that was in January 31st. And the meat in the decision was that certain provisions of the UPDF Act were unconstitutional, a decision that was in agreement with what the Constitutional Court had earlier on said 4 years back. What is your take on the case, on the decision as it was made, and what do you have to say about how the recommendations, not necessarily recommendations, but how the subsequent orders of the Supreme Court have been implemented thus far by the executive or by the judicial system?
In regards to my take on the decision, I think it was a longed-for decision, because as far as I know, the constitutional decision was made in 2015, So for us to have to wait for 9 years
I think it was like 4 years ago, if I'm not mistaken.
Yeah, about that.
4 years.
Yeah.
Yes, but still to have to wait
Yes,
for that
exactly.
time, for people to have to march to the Supreme Court premises for us to have justice then served is, I think, something that is long awaited for, was long awaited for, and should have been done much earlier. But when it comes to my take on the trend, I think it is a very good decision in terms of protecting civilians from being subject to military courts. We all know the challenges of military courts. The judgment spells them out. There is no possibility of fair hearing. The fact that you have someone that holds the president in high regard, not only in high regard, but is answerable to the president more than they are answerable to the people of Uganda, then means that the orders that will be followed will obviously not be things to do with constitutionality or justice, but simply based on what the president thinks is right. So I think in terms of it being a decision, it was a very good decision and was long awaited for. But I think the only downside is the fact that it still left the possibility of civilians being tried in military courts in the event that there is an amendment to that effect. Because they did not necessarily ban the trial of civilians in military courts like various jurisdictions. For example, I think in India, you cannot try a civilian in a military court, though military men can arrest you in the event that you do something like terrorism, but you're still subject to civilian courts if you are a civilian. So I think the downside of the judgment is that it still leaves the floodgates, because even if we are to have an instance where there is an amendment, and for example, you get maybe people that know the law or have an idea of what the law is into this system, there's a possibility that they would still have these military perspectives in their background. So from that, I think it was important for the court to totally ban trial of civilians in the military courts, but that wasn't done. But still, we will give credit where it's due.
All right.
Yes.
So I'll take you at that very point. If I'm to remember very well, the judgment more so that of the Honorable Chief Justice, Owinidol, he made some recommendations, and one of them was maybe if military courts are to be sustained, right, that they should maybe have civilians in them, or that they should have trained judicial officers from the military personnel. Don't you think that would solve all the challenges, more so with regard to a right of fair hearing that you're talking about?
I don't think it will necessarily solve the challenges, because you have to first of all look at the will of government to even implement that decision, right? Because the most likely that is going to happen is that, yes, you'll have people that have some judicial training and everything into these military courts, but at the end of the day, the likelihood that these will still be military men, they could be subject to some sort of military training because of how our government operates. They will still look for people that are loyal to the government. I would not look at the implications of the decision in light of strictly what the recommendations are, but also the nature of government that we have at hand. So even when the decisions are implemented, I do believe they will be implemented in such a way that protections like fair hearing would still be at risk.
All right, very interesting. Okay, I'll turn over to my left. Miss Praise Aloikin. We've heard over from Atai, and her position is that even with any changes that may be made in the structure and composition of the military courts, whether they're under the High Court or whether we get trained judicial officers to go and sit in those courts, there will not necessarily be a right to a fair hearing to the people in there. With your understanding of the right to a fair hearing and what it comprises of people being given an opportunity to present their case, them being before an independent person, unbiased person, them having the opportunity to have the public listen to their case, and all those other aspects. In your own perception, don't you think that some of those things are actually cured once we have the military courts having that structure being cured through some sort of like changes and training for the people that sit in them?
Okay, I'm going to take this a little bit to reality. The fact that even in the courts of justice, where we have learned justices who have been through law school, have been through LDC, we still see cases of abuse of human rights. Currently, we can look at the case of Aaron Kiza and Kiza Besigye under the Court of Justice Singiza. So for me, it's not just about the presence of an education. There is an entire system within which these people function. And I agree with Atai that even just this legal training or whatsoever training given to these men that work in the army is not enough to offer a fair hearing. Because if you look at the structure of how the army in this country is made and created, the fact that the president is the head of all forces in this country, and the president has shown to always be partisan, the president has shown to be the biggest abuse of human rights in this country. Just yesterday, members of the opposition in NUP were heading for a by-election, and we saw how they were beaten, we saw how part of them were abducted at the end of the day. So if within our structures we do not have things like separation of power, if within our structures we still have the issue of patronage, that even when the president doesn't directly give the orders, people looking to benefit from the patronage that exists will find ways to still, manipulate and attack people. And you need to understand how and where do civilians find themselves most times in the court martial. It's from political, dissent. It's a political tool to silence people of the opposition. It's around civilians having access to things like guns, but mostly it is to solve, even those young boys in Karamoja that are arrested, the fear is what if an uprising starts and these people have these weapons. So you need to realize that this is more politically motivated than any other, issue. So even though these people are able to receive this training, because they're already politically biased, they cannot offer any form of justice to these civilians. Now the question would be, if we take them to civilian courts, are they still going to receive justice? No, but it is a better chance than having them in the general court martial.
Okay.
Yeah.
So at that very point, in the recent years, we have had many instances of Uganda grappling with insecurity. We have a number of key figures within this country that have died at the hands of assassinations, through shootings, and many other people, many other instances. We have uprising, like insecurity, maybe in the northern region, because the number of people that have guns, like you said. And also you need to understand that there is when it comes to cases involving weapons,
Yes.
there might be some sort of detail that is needed, that is, and that knowledge of that detail is not necessarily with people, with civilians.
Yeah.
Same way how, for example, we have a labor disputes court, because there are some details that are not necessarily with the ordinary court structure. So don't you think that in light of those circumstances, then there is really a need for us to have some sort of military element within the court system, so that they can deal into those specifics?
No, I don't agree. I don't agree with that. Because if, for example, these civilian courts are envisaged to try people for things like terrorism, for things like treason, then they can answer questions to that. What is so different? And we have even provisions within civilian courts for expertise to come and give their knowledge. We have amicus curiae. They can come as amicus curiae. They can be called as experts on these issues to give their opinion. You get? So there is no need to say that, because this involves guns and arms, it should be taken away from civilian courts. But also, the reason why we have divisions like, we have a labor division, we have a land division, is not necessarily because these people are experts in those fields. It's because it's to divide and spread people across, creating, some sort of organization to which people can go to, but not really a question of expertise, because the very people that are promoted in these different divisions worked or served before in a different division. You get
the argument with the Labour Court is that, for example, it doesn't only have judicial officers. There are panelists who are specialists in labour affairs, who also contribute to some extent.
Who contribute to an extent.
Yes.
So is it a matter of contribution? I still believe that contribution can be made in the different avenues that are provided for in the civilian courts, you get. Because here we ask ourselves, what is the lesser evil? What is the greater evil? Because it wouldn't met out justice or give justice to take people to a people we claim are specialized in that issue, but history has proven that they do not get justice in that place. So are you saying we can do away with all other avenues that are created within civilian courts to try and offer justice to these people, you know, just because we are looking for that expertise, which I don't really get? Because, you see, it's one thing to claim that this issue is so different. It's unrelatable. People won't relate with it because they have not held guns or they have not, you know, dealt with arms. And yet the Constitution envisages that these very civilian judges are able to try things like treason, are able to try things like terrorism. So are we trying to say that Constitution was wrong in the first place to envisage that? You get. But also, if we want to try and claim that the General Court Martial was created in the first place because of its expertise, history still disputes that, because that's not the reason. The General Court Martial was created for that sole intent, to give power to the military to silence political dissent.
That was the historical background?
Yes.
Wasn't it more of solving disputes in conflict areas?
No,
or something
that
like
wasn't it.
All right. Okay. At this point, I'll go back to my right. Honorable Atai. The resolution by the NRM caucus has some arms of what should be amended in the UPDF Act, and amongst them is to take back civilians to the military courts, and but this is only for those civilians who are found in illegal possession of firearms. But then it also goes ahead to create an appellate system that they can appeal to the civilian courts after being tried there. The decision by the Supreme Court was to the effect that at no point should, it ideally barred civilians from being tried in military courts unless the structure of the court has changed. The UPDF proposed amendments do not seem to have that change in that structure. Now, what is your take on that in light of Article 92 that bars retrospective legislation, or legislation that has the effect of changing a court decision?
In light of that, it is a blatant and obvious derogation of an article in the Constitution, which is forbidden by the Constitution itself. Because, first of all, look at it from the practical perspective of everything, is that what is the point of having civilians tried in military courts? The point is one, it is not to give them justice or save the country from security threats. It is simply one, to sort of force people that are trying to fight for change, that are trying to get rid of this oppressive government, to cower into and give into what I mean is just...
But at that very point, you realize that the biggest majority of convicts by the military courts are people from the conflict areas in northern Uganda, not necessarily within the political sphere.
Can I say something? Just before you even... I think she still has a point, because, like I've stated, what was this conflict about? How did these people get the guns in the first place? You know, it has been from a place of political contestation. If you look at northern Uganda, it was Konyi. What was the question? It wasn't like civilians were getting guns and, you know, okay, let's go shoot each other. No. It all started from a point of political contestation. And therefore, even the greatest fear really, you know, of, okay, let us get these people with guns and fight them and stop them, isn't just from the mere desire to protect these people. Because if it was from the desire to protect the people within these areas, it doesn't take away the right of fair hearing for the people you're found with the guns. And from the background that we have given you, and that is emphasized in this judgment, is that these people cannot get a fair hearing in these courts as civilians? Do you want to hold them accountable? Bring them to courts where they can be guaranteed a fair hearing and justice at the end of the day. Because you cannot say, oh, there's insurgency, let's deal with insurgency, and then affect the right of this other person because of that insurgency. You get?
Okay.
I'm sorry.
And additionally to add is the fact that the General Court Martial has no supervision from any civilian. So whereas other courts are supervised, there is a hierarchy. You know that the High Court is supervising the magistrate courts. The principal judge has supervision powers over the High Court. The CJ has supervision powers over the Supreme Court. There is no supervision. The only supervisor is one. It is still the president. Even if he says nothing, the people on that panel already conceptualized what would sit right with him. So he doesn't even need to speak. They know what would sit right with him, and they would make a decision in his favor. So I think the problem with taking civilians back, and worse still, taking them back with no change in the structure of the court, is that you're simply doing what was undone. So you're making the court seem like Portia's Pilate, in that it said, I've washed my hands of this, I have saved you, and so now deal with your executive.
But you realize that this has been done in a number of times where certain provisions have been maybe deemed unconstitutional by court cases, but then due to the need, there has been.
It doesn't mean it has been legal. And I am sure if there was contestation on those various laws, they would be repealed if you go before a right-thinking judge. But then the question is, Justice Sekana has been moved to the Constitutional Court. What if, to the Court of Appeal, what if your judgment lands there?
Yeah.
Okay. Also, in that very regard, there is okay, you can finalize. I'm going to.
Yes. So for conclusion, I say that any amendment that doesn't include a restructuring of the court, in my opinion, I even think civilians should not be tried at all. Don't
the proposed amendments restructure it to the effect that they create an appellate system?
By the time you are done with, by the time you're done and been subjected to a military court, the possibility that you'll even have the energy to appeal. But even apart from that, look at the case of Olivia Lutaya. What if you end up like Olivia Lutaya? In that you are continuously put through a system, you come to court and you're sent back, continuously sent back, to the extent that you just give up and probably admit to what you didn't do because you're tired and the system has strangled you.
Okay.
But
so
also,
I generally think it's just creating more bureaucracy, in that you finish General Court Martial, then you're going to High Court. After you go to High Court, then you go to Court of Appeal. You're just creating a long chain, and that is more time for you in prison. And it is known that in some instances, there are some people that be on remand till beyond the proposed sentence for that offense. So if you're now adding the General Court Martial to that, you are just delaying justice.
Isn't that characteristic of the criminal justice system as it is? Because there are also magistrate courts.
But then you're making it worse.
it doesn't make
So
it
what I'm
perfect.
trying
It's
to
not
say.
that. It's not. Yeah.
There is no perfection, so we are struggling with case backload this
Already,
side,
yes.
and then you want to add an extra court and an extra appellant system.
And to add on that, Mahad, the fundamental thing here is that justice and a fair hearing is not guaranteed in this court. It doesn't matter how many layers of appeal you add in that system. If that system doesn't guarantee justice, if it doesn't guarantee a fair hearing, adding on, so many courts above that just creates more room for abuse. Because what happens if, I win, because both parties can appeal. So, it creates room for more abuse. The issue is, how do we deal with the issue of, the entire problem? I know sometimes I say this and people think I'm delusional. That if there is no separation of powers whatsoever, no system can function. Not the parliament, not the judiciary, not even the executive itself. You get? And without addressing the core issue, which is a broken system, the fact that we are no longer operating as per stated by the 1995 Constitution. everything becomes mere rhetoric. We can have this conversation. Because I was part of the young people that marched for this decision. And this decision came. And we are stuck here because, the president went and wrote a letter and said he disagrees with the decision of the court, and Uganda is not run by court.
And his son made a comment.
Exactly.
Which has moved the NRM caucus.
Exactly, thank you. And the NRM, who are the majority, already sat, and they have this. I bet they don't even understand the gravity, the implication of what they're doing. But it's because a little money was dished into their pockets. You understand? So all the questions you ask, in the back of your mind, you should know that we are operating in a failed and broken system already.
Okay. Is it okay? Ideally, even your argument is that the system is broken.
Yes.
And recently there was a report by the Human Rights and Peace Center at Makerere University, where they were examining the extent to which the military has gone into other sectors. And the argument was that the overall argument of the report was that there's been an increased role of the military in all other sectors.
Yes.
So, what is your take? Does the military getting involved in the criminal justice system, right? Does it solve anything at any particular point, or it is taking us backwards?
If you listen to Museveni's, someone said this. He calls it Musevenism or something, or the Museveni ideology. He's a young man, I forget his name, but he wrote something around that. And I got a chance to interact with him, and it made a lot of sense, and I think it's relevant in this conversation. You need to understand that right from the time when Museveni was coming into the system, through NRA, through his different campaigns, when he became president, he was so vocal about this, but now he's no longer vocal about it, he acts it. And Museveni's ideology was simple. The fact that the military needs to take power. And he heavily condemned anyone who conformed to any other form of governance. He called us, I think, Westerner, whitewashed by Western ideologies to think of things like democracy or autocracy as the only forms of leadership. For him, he always carried the idea that the military could run a country. And he was vocal about it. He's no longer vocal about it, and he acts it. And that's why you see militarization in all. Is it in the labor department? You'll see them building buildings. Is it in civilian spaces? You'll see them everywhere, even where the police is supposed to be. There's always an excuse to put in the military. They even create a whole docket and call it the military police. So you realize, is it the health sector? There is a militarization of that. They are now in parliament too. So the whole idea of militarization is Museveni's idea of capturing the state, because when you have guns, you have power. You create fear, and that's a tool he has used. You create fear. You can consolidate power. That's why we have someone who has been in power for the last, 40 years. And because now people are keen and understand this, it's even more complicated for him to do it without having the military in all these spheres. So having the military in a place where human rights and justice is supposed to be meted for a system that has encroached on the rights of people time and time immemorial. That's what the army is known for. Time and time immemorial, it has encroached on the rights of people. You cannot, is it war? Is it even where they are fighting for change of regime when the NRA was fighting? There will be always an abuse of human rights. Women will be raped. Children are going to be recruited within this army. So the army, from its very existence, has never, ever understood the concept of human rights, understood the concept of humanitarian justice.
At that very point,
yes.
At that very point, I don't remember the article very well, but when you read the Constitution, where it provides for the UPDF, it gives UPDF the mandate of protecting the country, but also participating in developmental programs for the country. And there could be an argument that by bringing the military into these other spaces, into the health sector, into parliament, it is to avoid them from being alienated and idle, and hence. So don't you think that is a positive move? Because
idle from what? There are people you say that we have a lot of conflict around our borders. We are surrounded by a conflict zone. They can go and do their work there. And if you want to use that as an excuse, like, oh, we have a military and it's idle, it's everything, I just want you to see it in a different way. Look at the JAT. Look at all those different armed, militarized bodies that the government tries to create. Over crime prevention. It's always everywhere. They find a way to give guns to people, and not just to any people. And it takes me back to the argument of, oh, these people have guns and they're, torturing people. No. The issue of this government is not people having guns. It's the fear that the people that have guns are not supporters or diehards of this government. So they are free, they are able to give you guns as long as they can take you to Chankwanzi, indoctrinate you to know that NRM is what you're supposed to die for, and if they send you to stand on a man's car and shoot him because he's putting on red and he belongs to Noop, you don't give a second thought to it. Okay. So the whole idea of militarization is not, oh, let's inculcate. What do you mean inculcate them in the system? Okay, then let's inculcate doctors everywhere. Let's take them to courts. Let's take because they are idle. Let's inculcate farmers everywhere. No.
Okay. In light of that,
yes.
How then should the military participate in the developmental programs of the country?
What do you mean developmental programs of the country? Do your duty, serve your part, go and protect the country at the borders.
Obligation.
And the constitution in and of itself is not correct entirely. There is good law and there is bad law. And whoever wrote that, I do not know what they were envisaging, And I've already told you, the man who was behind that constitution himself has always had militarization as one of his agendas. There are so many laws that are repressive, women laws that have been quoted before and have been amended and have been changed. And to weigh the merit of that law is, okay, look at the effect of that law. Look at the effect of that law. Okay, we're having the military everywhere. How has it affected the civilians? Has it been positive or has it been negative? And I think that's a consensus we all have here, that it has been largely negative.
Okay. Thank you very much. So your position is that that particular provision of the Constitution that gives the military that obligation does not, it's bad law in simple terms?
Yes, it's bad law in practice, especially in an army that is not patriotic, that the only peopleness about it is in its nomenclature. Uganda's People Defense Forces. In their practice, they are captured by the government. They have shown to be foot soldiers of this government and not soldiers of the people. They do not stand for truth. They have fought every little democratic thread that exists within this country. They are the ones used during elections to kill people, to shoot people, to abduct people. They are the ones that instill more fear and take away power from the people where it's supposed to belong.
Okay.
So yes, I agree and say that that's bad law.
Okay, thank you very much. At this point, I don't know if it's still recording. Okay, at this point, I will take on Atai. What is the effect, in your opinion, what is the effect of these proposed amendments on the idea of separation of powers as is envisaged in the Constitution?
Yes, in terms of the effect, it simply undoes what was initially done. Because while the judiciary, one of its roles is meant to sort of have justice served to the people, right? That role is, in most instances, opposed to what the executive would do. So what the executive is simply doing is saying that the military, I beg your pardon, the Supreme Court has given citizens justice. And we are going to interfere with them doing that duty, and we are going to undo what they have done. And you see, it's not even, there is no recommendation being followed because there is no proposition of a change in structure. If they were saying that, if for example they were saying that we are changing the structure of the military courts to the extent that you have people on that panel that actually went through law school. If for example you're going to have an instance where you have no military affiliation of that particular panel, then you could argue that it will be, justice may be served in such a court and a fair hearing may happen. But that is not the case. What they are doing is simply creating an extra appeal system. And may I still stand by the fact that no civilian should be subject to military law. Even when you look at countries like the USA that subject civilians to military law, they only subject civilians that are subject to military discipline. And those are to service discipline, I mean. And those are civilians, that, for example, could be contractors or work in the administrative section
Of the
military.
Yeah.
But you cannot get someone that has never envisioned being part of the military justice system and subject them to that. Because what military courts do, or what the state does, is that it can say you were in illegal possession of arms when they themselves put the arms there, or when even no arms even existed.
Exist in the first place.
So if they're going to still subject you to a court that is loyal to the president, at the end of the day, even the investigation itself, from get-go, is tainted. So the challenge with that is that I think the state is entering into the business of the judiciary by undoing what they have done. And additionally, they are not even following the recommendations of the judiciary.
Okay. And where does that leave the legislature?
That it simply shows that the legislature we just do not have separation of powers at all in the country. Because where the judiciary, for this particular case, because we all know the judiciary itself has its flaws, but for this particular case, it did as well. But then you have the executive, first of all, influencing the number of people that are in parliament, ensuring that his party is the majority. And at the end of the day, you know what the decision is going to be. NRM is the majority, no matter what the opposition leaders say. That bill is going to be passed. And it will probably be contested in court. So the question is, if it is contested in court, will justice be served? Or for how long will it take? Or will justice even be served? Because there is a possibility that you'll go to the Constitutional Court and it says there is no problem with it. Yeah. And then you'll have to go back to the Supreme Court and wait for the Supreme Court to pass the judgment. And you cannot even go to court to dispute it now because it's not yet even law.
What I dispute.
So you're going to have to sit and wait.
But you can protest.
So by the time that happens, people will still continue to go to the military courts, will still face unfair hearing, and will still face the same injustices.
All right. Thank you very much. Interesting discussion. Okay, so I think we're coming to the conclusion of our podcast for today. I think where should I begin from? Parting shots about the whole situation.
It's okay.
You have a minute.
Yes, so in terms of parting shots, I generally just think as a country, we are sitting on a ticking time bomb. And it's not strictly about trial of civilians in the military court, but it's also about the military literally being forced into every other space. In the fisheries industry, it is there. A report by Fian was written on the challenges of having the military court into the fisheries industry. In the education sector, they try to penetrate every sector. What I'm trying to say is that the military should just get out of our business, and that is not going to happen by us sitting and folding our arms. We actually need to resist this sort of invasion. I call it an invasion. I don't think.
Invasion into what?
Into the civilian spaces, into everything, and an invasion that is meant to ensure that the president stays in power, and when the president leaves, his son takes over.
All right, thank you very much. Praise, over to you in 1 minute.
Yeah, mine is just that, you see, we can sit and have these conversations all we want. And they are very important part because they are a good place to agitate, they are a good place to debate, they are a good place to inspire opinion in people. But after these conversations, what do we do? What do we do? And every Ugandan needs to get to a point where they realize they are, like she said, it's a ticking time bomb. But it can tick in our favor or it can tick in their favor. You get? If that bomb blasts, Museveni can come out of it as a lifetime president and this becomes a monarchy of sorts and, his family can take over. Or we can come out of that where power now belongs to the people and people have power over the different leaders in this country and there is separation of powers and there is an actual democracy and not an isomorphic mimicry that we have currently. And that can only happen, that all is determined by the actions that the civilians choose to take today. You get? And it's one answer that we can run away from in circles, and that is revolution. And not every revolution means pick up guns and go to the bush and kill people. Sometimes revolution is just utterly disobeying anything. Is it paying taxes? We say we shan't pay the taxes. Is it marching? We shall march. Any form of resistance that shows this government that we have understood how it works, we have understood its tricks. Now, when it comes to the decision of the Supreme Court, what I would expect now is a protest from all legal practitioners. Why are you still practicing? What is your voice? Why are you still okaying this? Now, Parliament is using this opportunity to, do whatever it's going to do because, NRM has a majority. Are we waiting for that bill to be passed? And then we go to these very same courts we have agreed with are unfair. And then a few, 2, 3, 4, 10, 100 young people will be on those streets and they'll be arrested and they'll be put in and they'll be released because they are just 100. But if everyone stood up and fought and we didn't create a system where there are few people fighting this system, such that they can easily be picked out, they can easily be abducted, they can easily be targeted, then we move closer to creating a better system. So for me, the solution is one, and a total overhaul and resistance that is people-centered, that is leaderless, that is partyless, that is issue-based, that is tribeless. Because even, I'm sorry I'm overextending, but because even these opposition political parties themselves are no longer with the vision of revolution. It's just about who becomes the next president for them. You get. So how do we change that entire system to create the better system?
Right. Very interesting. Thank you very much, Praise. Thank you very much, Atai. These have been your guests on the Constitutional Talk. We have come to the end of our discussion for tonight. I want to thank you for tuning in, for watching, wherever you are. I also want to send our shout-outs to Nyango. He's the man behind the cameras. I want to send shout-outs to Louis at Unipod. And send shouts-out to the team at Lexamica. Do not forget to follow Lexamica. And this edition has been brought to you by Lexamica, Makerere University Innovation Hub, United Nations Development Program, and Timbuktu. This remains the Constitutional Talk. Thank you for tuning in.
By the way,
those government people should have been.
They called, I don't know if it was still recording.
Even me, someone called me. Whose number is this?